Welcome to RevGen's webinar on data privacy in the California Consumer Privacy Act, establishing trust and protecting your brand. I'm Per Dalkowski, Director of Data and Technology Solutions with RevGen Partners. In today's webinar, we'll be covering the current state of data privacy regulation in the US today. We'll be delving a bit deeper into the California Consumer Privacy Act itself. And we'll also be laying out some very pragmatic approaches for organizations to become compliant with these regulations. Before we dive into the data privacy content, I did want to take a brief moment to introduce RevGen Partners. We are a business and technology consultancy based out of Greenwood Village, Colorado, and we service our customers across a few primary areas: digital enablement, customer experience, and analytics and insights. And I think you'll see that the topic of data privacy really crosses all three of these when we go through the content today. At RevGen, we are fortunate enough to work with clients from all different industries and all different sizes, from mid-market all the way up to Fortune 50. And we're very proud to say that 90% of our clients re-engage us for repeat work. At RevGen Partners, we believe in empowering people, employees, clients, and those within our communities so we may all aspire to be more. And we do that by living our values of respect, integrity, and stewardship and enjoyment every single day. So let's talk about data privacy and why organizations should care. Why should the folks on this call care? What is it? Well, to me specifically, data privacy centers around the proper handling of data based on classification, application, and level of importance. Data at an organization can take all shapes and sizes, and not all data is created equal. There's data for marketing and sales purposes, there's data for service delivery purposes, there's data for service reliability, even data for monetization in some organizations, and all of that requires very specific handling. When I think about data privacy, three key areas are top of mind for me: what data is being collected, how data is being stored, used, and protected, and then what data is shared and how and to whom is it being shared with, right? So data can be shared, with a very select few individuals at an organization on a need-to-know basis. It can be shared across an entire business unit, and it can be shared across an entire organization. And very differently, it can be shared with a third party external to that organization. So data privacy itself has a variety of different use cases. We'll be focused on personal data privacy in today's webinar, but there are other types of data privacy. There's data privacy considerations for financial data at an organization, for R&D or product dev data, intellectual property, so on and so forth. But again, today's webinar will be focused primarily on personal data privacy. So getting back to why organizations should care about data privacy. Customer trust, first and foremost, in brand reputation, right? If organizations are not handling data to the level of expectations of a customer, and that becomes known to the market and to customers, that organization can take a very big brand hit, which we've seen specifically in social media organizations as of late. And that can have a big financial impact to the firm or to the organization. Another reason organizations should care is because of revenue streams, right? So there's been a lot of talk of data monetization in recent years, and that is really about selling data to third parties for profit. And some organizations have done that very well and have achieved large revenue streams, new revenue streams, and some have attempted and not done so well. And if you do not take the proper safeguards, precautions, controls when doing that, you will likely end up on the latter side of that, and not having a sustainable revenue stream, and that could actually come with very significant costs to your organization as well. And thirdly, regulation. We will spend a lot of time in today's webinar focused on regulation. And this projection by Gartner is very telling, right? If only 10% of the current personal data is governed under modern privacy regulations, and that is expected to jump up to 65% within just the next few years. That tells me we are just in the infancy of data privacy and these regulations, and that it is going to garner more and more of our attention, so we should all be paying attention. And Joe will more specifically jump into the regulatory aspects of data privacy, as well as some of those pragmatic approaches for compliance here in the remainder of the webinar. So Joe, if you could please take it away.
Yeah, thank you for that, Pero. And yeah, again, we are a consultancy, so we have quite a bit of experience in working in this particular discipline across a wide variety of organizations and groups and so forth. And so this will likely be one of a number of data privacy conversations that we have. And so to that end, what we really want to do is start at the beginning and break down data privacy in terms of the value that it brings to an organization, and then continue to drill in from there. So the first pillar of the value that I want to talk about really is about compliance, right? So what organizations are eligible for this California Consumer Privacy Act legislation that has been put into effect, right? And it's any organization that has over $25 million in revenue, accumulates, sells, buys, or receives personal information, or derives 50% or more of revenue from selling PI, okay? Now, the second pillar is really around consumer trust, right? So anytime a consumer interacts with your brand, it's an opportunity to build trust with that particular consumer. And we're going to drill in on that concept here in a second. So, but from our perspective, it breaks down into building consumer trust through PI data transparency, creating a positive consumer experience overall, and generating those positive emotions. And of course, protecting the brand, right? Ensuring that there's no information or data leaks related to personal information, and that folks know that they can trust your organization with their data and their information, so that you can focus on delivering your value add services to them. And there's of course a value component to data privacy in terms of the practical application of managing data privacy. And so from a legislative perspective, there's a $7,500 fine per violation. But data privacy, as Pero noted earlier, is something that is growing. It's an area that's growing. And so organizations, we believe, need to build forward-thinking infrastructure to not only support the CCPA, but other aspects of data privacy. And we're going to talk about that here in a second as well. And then, of course, building out the right infrastructure, that's going to take time. It's going to take money and resources. And, if you can engage organizations to help reduce the time it takes to implement and get it right the first time and ensure it's compliant, then that certainly is going to save you money in the long term. And it will also help you ensure that you're, building that forward-thinking infrastructure. So let's take a moment to drill in on the compliance requirements just a little bit more. So from a general overview perspective, CCPA was signed into law on June 28, 2018, okay? So there was a delayed implementation which went into effect on January 1, 2020. So basically what happened was the state of California gave folks, organizations roughly 18 months to go out and build the necessary infrastructure to properly manage data privacy against the regulations. Then what happened was, or what the legislation calls for, is public enforcement of CCPA beginning on July 1st, 2020. So ultimately what that means is the California Attorney General can go out and start to ensure that folks are properly compliant with the legislation and that all the requirements have been met. Now, the legislation calls for a fairly broad definition, right? It's not just individuals that are subscribing to a service provided by our organization, but it's rather geared towards consumers. So if you think about it, a marketing organization might collect a broad set of information about individuals that they want to go market against to, have people subscribe against their service. And if that information is collected on that consumer, not just the customer, can launch a request. And we'll talk about that here in a bit more in a second. It also broadens the definition of personal information. So we'll talk about GDPR here in a second, as well as some other data privacy legislation, but it broadens it from the definition of PII, and so it starts to include more data elements than prior state or federal definitions have defined previously. Okay. The areas of application. So an individual can request an access to the information, right? What information do you have in relationship to my profile? An individual may also request the deletion of information or some combination thereof. And we'll talk about that here in a second. And there's also a portability rights element to this, right? How portable is the information that's being provided to you as a consumer such that you might be able to load it into your own personal profile or what have you elsewhere? There's also a dimension of this that calls for the opt-out for sale of personal information and for the opt-in of sale for minors. So a minor has to opt in and give, express consent to use information and so forth, right? And then there's persistent opt-out across devices and methods of interaction, including third parties. So vendors that have some sort of relationship with your entity are also encapsulated into this legislation. The outcome of this also is the fact that the Attorney General has enforcement and rulemaking authority over CCPA. So they can levy fines, they can come in and basically look to make sure that you're compliant with the legislation, and ultimately they can ensure that the legislation was rolled out within your organization properly, and that you are compliant. Okay. So let's talk a little bit more about the brand aspect of this, right? Anytime an organization or anytime a person or a consumer interacts with your brand, it's going to generate some sort of emotion, right? So if you think about it, if someone has a negative experience with how you have managed their data, their personal information, things that are associated with their profile, such as their email address, phone number, address, account information, and so forth, there's always that possibility that they could walk away very dissatisfied, very disappointed, or stressed, or frustrated, unhappy, right? There's this, underlying sentiment that, I want to be able to trust an organization with my personal information. Now, the flip side to that is, if they have this interaction with your organization and they feel like you're properly handling their PI and you're creating transparency into how, their PI is being managed, there's always this, element of feeling valued, feeling that your information is safe, trusting your organization, being confident that you're going to properly manage their information, and so forth. So there's really an opportunity from a brand building perspective to create those value-adding emotions related to personal information, so that folks walk away knowing that you're a trusted entity and that they can do business with you and trust you with their personal information. Furthermore, what we've done is, in a very practical sense, developed out a calculator to quantify the value of properly managing data privacy, right? So there's this element of, what is your IT spend today if you were to sort of, just handle these types of requests in a very ad hoc perspective, right? How many requests might you receive? How many people do you have to throw at it? What are the potential for fines if you don't get it right, and so forth, right? And what sort of IT and operational infrastructure costs would be in place to handle those requests in a bit of an ad hoc format, right? And there's an element of it, well, if we put the right system and the right infrastructure in place, if we build the right forward-thinking infrastructure, what might that do to our business in terms of IT efficiency gains, in terms of operational efficiency gains, such that we find a delta between this sort of inefficient environment for managing data and the efficient environment for managing personal information. And then what we've done is we've said, okay, well, look, if you properly manage that infrastructure, it's going to take some upfront costs, right? And then, you have the, potential savings of that over, a period of time. And what might that return on investment be, right? Dollar in, and, projected into, let's say, some sort of 6x or 15x, return on investment for each dollar that you invest. Okay. Now let's pause for a moment and talk about data privacy in general. So GDPR was adopted on the 14th of April in 2016, and it really became enforceable beginning on the 25th of May 2018. And as you can see here in this chart, right, there's quite a bit of information, but the important aspect of this is, it gave people the right to know what information a business has collected about them, the right to say no to the sale of that information, the right to delete it. It gave them certain protections from a security perspective, and a whole, variety of other provisions that help protect that consumer and their personal information. And the net of it is that it really put them in control of their data, such that, people had, or could feel safe about how an organization was managing their information. Now, California has been the first state to take steps towards replicating GDPR. And you can see CCPA right here and how it stacks against GDPR in terms of, capabilities, in terms of requirements, and so forth. And, it's made some significant strides towards protecting U.S. consumers that, do business in California and so forth, right? But you can also see here that there are a number of gaps, right? So California is looking to take that one step further. Those gaps, they're looking to address them in the form of what's called CPRA. CPRA is actually on the ballot, or it's a ballot initiative that has made it to the ballot this November. So it's going to basically be up for approval by the voters in California. And, basically what it does is it gives the organization, or gives consumers another step towards becoming more in alignment with what is being provided in Europe from a GDPR perspective. Now, I want to pause here and touch on one other aspect. So there's an element of CCPA that allows for them or provides for the management of employee and B2B data. That has actually been pushed out until 2022. So basically, AB 1281 was an amendment that was signed by or put into effect by the state of California, and it pushes the legislature or pushes the enforcement of that out until January 1 of 2022. Now, if CPRA passes in November of this year, it pushes that employee and B2B enforcement out until January 1 of 2023. So we'll have to see how that all plays out with respect to CPRA and AB 1281. But please do keep that in mind if you're looking to manage CPRA versus CCPA right now, employees and B2B. Now, let's take a step back and look at data privacy at a national level. Now, when you look at how data privacy is being managed domestically within the US, right, you've got the state of California, which is really the only state as of right now that gives consumers the right to access and the right to delete, plus the right to opt out, okay? You have the state of Nevada, which provides provisions for individual consumers to opt out of the use or the sale of their information. And you have the state of Maine that provides provisions for consumers to opt in. So you actually have to give them permission to use your information and to sell your information and so forth. There's also quite a few other states out there. You can see here North Dakota, Hawaii, Maryland, New York, Massachusetts, that have pending privacy rights legislation. So this is certainly something that's very much top of mind for many states, many consumers across the US right now. Okay. Now, let's take a moment to look at this business problem at a 50,000-foot level. So we talked a little bit earlier about an inefficient operating environment, and I want to just kind of paint that picture for you if I could. So imagine a consumer, and they've got some personal information that they believe an organization has in relationship to them. So what they might do is they might call a call center and say, hey, look, I'd like to access my information, or I'd like for you to delete my information. At which point that request has to be captured, perhaps by the call center, and then it has to be distributed across a wide variety of business units, each with their own disparate set of processes, data sources, systems, the variety of different vendors that they're managing. And it's in this particular scenario, it's very likely that each of these different groups has their own means of managing processes, data sources, systems, vendors, and so forth, right? Furthermore, that information has to be collected, gathered, identified in terms of personal information, which, based on my experience, is no simple task. It then has to be properly processed through, perhaps some sort of data processor, folded into some sort of output file, and it can't just be any output file. It's got to be one that is compliant with the regulations and properly communicated back to the consumer, such that it passes muster with the California regulatory body and the AG that might come in and probe what's being posted. Okay. So based on our experience, a consumer that engages your organization and let's say has an experience with a well-defined portal or some sort of well-defined interactive voice recognition software, such that the request can be accessed and the access or delete request can then be methodically distributed to a variety of different business units and then funneled through a unified process such that each and every one of those data elements is being delivered in a predictable format. It can then be managed via a data processor and basically consolidated into a consistent output file that in our experience has been reviewed by, let's say, a legal department, program management office, IT group, corporate communications, and all of it, looking through the lens of how do we make sure that we give a very, positive consumer experience to the requester, but at the same time ensure that we're compliant with AG regulatory requirements, right? And so in our experience, building, the proper output file and working your way backwards towards a very positive consumer experience, such that they have, a very positive emotion when interacting with your business as it pertains to PI. That's, the secret sauce to ensuring you have repeatable, scalable, and measurable platform. Speaking of measurability, it is our experience that, as you systematically process this information, if you've got the right systems in place, you can then go in and create what we've, ultimately created here, which is a waterfall analytics view, right? So you can look at, what's the total number of record submissions via your website? What's the total number of record submissions via your interactive voice response, right? How many of those have been consolidated into some sort of compliance repository and distributed out amongst the various business units? And how are you measuring the business unit responses such that that your access for requests and access for deletes and so forth are properly being managed, and what the cycle times for processing those records are by BU, right? Then once you have that information, you can then start to measure and track, well, how many of them made their way out to the consumer? How many of those requests were actually accessed and downloaded by the consumer? And you may also want to interject some sort of quality check process along the way as well to make sure that you've got the right information making its way to the right person and so forth. Okay. So I want to pause here and talk a little bit about things in terms of operational efficiency. So if you think about each business unit, each one of those BUs is very likely going to receive some sort of record request, if you will, right? So here I'm Joe Hum, I launch a request. My request is then going to have to make its way into BU1, BU2, BU3. Each one of them is going to have to go in and interrogate their respective system, look for personal information, extract that information, and then again, provide it back into the centralized process. Now, in an operationally inefficient environment, that's likely going to take some 1x processing time for each one of those record requests to occur. Now, conversely, if you basically put infrastructure in place, it's been our experience, and we have hard facts and have measured this, that you can basically drive down cycle times in processing those records, such that you've got perhaps a 40% efficiency in processing each one of those records, right? So you can think about what that does for your organization in terms of not only compliance to ensure that you're getting a regulatory compliant response out the door, but also that what it does in terms of reducing the number of people that you have to throw at the problem, such that you're processing each one of those requests. Okay. Now, I also want to talk about things in terms of IT efficiency. So if you think about a potential scenario where you have each different business unit operating very independently, right, in sort of a disaggregated methodology, you're very likely going to be in a scenario where each BU has its own process, its own set of data sources, its own means for extracting that data, no sort of unified format for providing that data into some sort of data processor. And then it's going to take, sort of Herculean efforts to try to pull that information together and generate some sort of output file that can be easily consumed by the consumer, right? Now, you might imagine that in that particular scenario where you've got all these different systems and data sources and processes and this Herculean effort to kind of knit and tie it all together, you're going to have to throw a lot of heads at that business problem. Now, in our experience, right, if you think through sort of the development of this infrastructure in terms of, okay, we've got to put a little bit of time and energy up front into building this out, but once we get the system infrastructure in place, we're going to have a very sort of streamlined way for processing each of these. We're going to have a streamlined way for extracting the data and information. We're going to have a consistent set of processes across all of our BUs. And then we're going to have, a predictable output format that makes its way to the consumer. Oh, and by the way, your organization may have to provide some addendum files depending on, whether or not you have certain scenarios where you have high volume data, right? So, in this particular scenario, if you put the time and energy up front to get, this sort of IT efficient infrastructure in place, and that could come in the form of off-the-shelf software, or it could come in form of, repurposing existing technology assets that you have across your business. It really puts you in a scenario or a situation where, you can reduce the overall number of headcount, right, that you have managing this entire environment. Now, we've broken down the value of data privacy, but I want to take a moment and sort of redimensionalize data privacy in terms of, what are the challenges that we've seen organizations have to try to tackle, such that, they can create a positive outcome, right? And so, we see organizations that, perhaps have inexperience in outlining consumer data privacy. I mean, this is, you've got a million different, opportunities and problems to tackle across your business. Data privacy is just one of them. So, this may not be a core competency of your organization. To that end, you may have very little data privacy knowledge, right? To drill into CCPA, drill into GDPR, that's not an easy task, right? Undefined data privacy regulatory processes, right? So again, if this is not a core competency of your organization, you may not have fully fleshed out processes for managing, the data privacy in terms of, how GDPR wants you to manage it, how CCPA wants you to manage it, what's the overlap, and so forth. You may have unknown technical needs. So to that end, it's our experience that you can either deploy off-the-shelf software, or you can tie existing assets together. Each one has its pros and cons, and you're going to want to, as an organization, try to figure that out. And then, of course, you might not have knowledge of, the final output file requirements, which obviously is one of the most important aspects of this, right? You want to make sure that you get the proper file format in the hands of the consumer such that you're compliant with, the regulations. So, resulting from inexperience, you might have confusing policy, site, and navigation, might have poor consumer experience. Resulting from little data privacy knowledge, you might not have the best implementation, which might increase costs. If you have an undefined data privacy regulatory process, you might have sporadic processes across the business, and that you might create somewhat of a poor operating environment. If you're unfamiliar with personal information, you might have some difficulty identifying personal info, and that could create some compliance risk for you. If you have unknown technical needs, it might be difficult to figure out, well, what can I repurpose, or what do I need to go out and buy, new in terms of technology to meet the minimum requirements. And that could increase costs and architectural challenges if you don't have experience in that area. And if you don't have the knowledge of the output file requirements, right, it could create sort of a challenge for you to try to define that final output, right, beginning with the end in mind. And that could create some sort of regulatory compliance risk. So it's our experience that, it's important to look at, these various potential challenges and to really do the right upfront assessment, right, within your business to ensure that you've got the proper strategy in place, okay? And the methodology for doing that is, one, we very much recommend that you align on the legislative principles, right? Take a look at the construct of CCPA, take a look at the construct of GDPR, take a look at the construct of CPRA, and really understand what's in the legislation, because I think that's incredibly important. We also think it's important that you assess within your business what personal information you have, right? It's our experience that the technology aspect of this is very, very important, but understanding what PI is based on what is defined within the legislation and where PI exists across your business is paramount to the success of your overall project. Assessing your technology infrastructure, again, is very, very important, right? In terms of how do you efficiently process each request? How do you make sure that request, is making its way out to each business unit? Make sure that each business unit knows how to handle each access request, each delete request, and again, it's our experience that, each of those BUs has a clear set of rules of engagement or operating requirements. When you're going out to deploy, it's also our experience that, defining the right project governance model, right? What are the various work streams? Who needs to be involved? How should they be involved, right? That's also going to contribute to the overall success of your project. And then, of course, taking all of these key elements and knitting and tying together the right privacy plan, right? How do you build out the infrastructure with the right architecture diagrams, the right decisions around technology, the right decisions around what PI information you have. Everyone fully aligned on the legislative principles so that you can go out and execute, right, efficiently and effectively, such that, the outcome that you create is compliance and project and cost efficiency and so forth, okay? So let me just pause here and share with you an example or a case study of a data privacy project that we've conducted. So we had a large communication service provider. California passes the legislation. They knock on our door and they say, hey, look, we would love for you to come in and help us, assess the legislation and translate that into what ultimately turned into a program management office and a group that help them basically identify PI across the business and methodically usher that into a technology solution that we helped architect. So, in the end, what we've done is we've helped them assess the situation, which of course is to enable customers to have full control over their data, which is, tenet number one of the legislation, right? Help them understand what infrastructure they needed to put in place so that, they could efficiently and effectively process each record. And then to translate, basically the legislation and the need into the proper approach for the business. And the outcome that we had was, a fully efficient and operating environment, both technically and functionally, which created increased transparency and trust for the consumer. We're getting the files out well under the 45 SLA day that has been created by the California Commission. Significant savings in IT operational efficiencies. So at the end of the day, I think we have helped them deploy this in a very, very cost-effective manner to not only meet the minimum requirements, but to exceed the minimum requirements and to create that positive consumer experience. But I think most important of all is we help them ensure compliance with the regulations, right? So if the California Attorney General comes knocking on their door to say, hey, I'd like to pressure test what you've built, they could sleep soundly at night knowing that what's in place is quite robust and will pass muster when the AG knocks on the door. Okay. So in terms of assessments, so we talked about that assessment to get to that positive outcome that I just discussed there in terms of a use case, right? So aligning on the principles, right? So, engaging an organization to understand those principles, we think is very, very important, right? What is in CCPA? What's important, right? What do I need to know that's in that legislation to translate into operational and IT infrastructure? Assess the personal information. So again, I think this is a little bit of our secret sauce, is that we've developed a very robust methodology to help organizations, go from business unit to business unit, identify PI, document it, socialize it amongst the business, ensure legal and the most senior of executives have visibility into this, and so forth. We also, again, think it's important to have the right governance model, the right work streams. Of course, the right technology infrastructure, perhaps using one of our partners like OneTrust, or taking your existing technology assets and tying each of those together, and then of course building out the right project plan that takes all of this into consideration. Now that of course fits into a larger picture of, okay, now we've got everything pulled together, we've done all of the right analyzing and planning up front. I'm sure, like many people on this call have done in the past, once you do your analyze and plan aspect of the project, you can then begin to transition into the design, where you can get the appropriate governance model into effect. You can develop your personal information catalog. You can ensure that you've got a fully defined and pressure tested architectural diagram. You can ensure that you begin to construct and design the exact consumer experience you want out of data privacy. And then of course you can begin to build the overall infrastructure. And then as you're building the infrastructure, I'm sure everyone on this call has had the experience of making sure that you manage the plan, the risks, make sure that you manage your risks such that they don't turn into issues, build out the right technical infrastructure, and then at the end of the day, build the right consumer experience. And then of course, go out and test the end-to-end solution to ensure that it's robust, sound, and that you're not going to have any sort of bugs or glitches along the way once the solution has been put into effect. Now, again, it's our experience that if you do this upfront sort of assessment, if you do this, or if you put the right infrastructure in place, you're gonna again accomplish three things. You're going to make sure that you're compliant with requirements, right? You're going to efficiently and effectively put the right infrastructure in place. You're going to lay the groundwork to drive down costs for future data privacy projects. And you're also going to put your organization in a position to avoid fines and so forth. We think you're going to build consumer trust, right? Based on our experience, if you come in as a consumer and you can easily navigate the privacy policy, if you can easily navigate the submission engines, whether that's the website or the interactive voice response technology, you're basically going to build your trust with the consumer. And then, of course, you're going to avoid fines, right? The fines can be quite significant if the AG comes in and perhaps slaps you with the fine for being out of compliance. Perhaps not having a lot of experience in data privacy could drive up your implementation costs, could drive up your overall technology spend as you kind of poke around and work to try to get it right. And then it could drive up your overall costs in terms of cycle times for processing records or throwing resources at IT and so forth. So again, this is our experience to date. We wanted to take a moment to share this with you and with the marketplace. And then again, it's our hope that this is one of many webinars that we have on the topic of data privacy, as there's much more that we'd love to share with you as we drill into everything from building out the right technology infrastructure to properly managing things across the organization to drive operational efficiencies, to getting to the right reporting metrics and so forth. So each could be potential topics that we tackle in the near future. But nevertheless, we wanted to make sure we walked you through this, and we very much appreciate your time this afternoon. So Lisa and Pero, I'll pause here and open the floor up for questions if anyone has any questions.
Hey Joe, this is Blake. Looks like we got 2 questions in. I'll keep my eye open in case any other ones come in, but the first one I'll throw at you is, what's the difference between CCPA, CPRA, and Amendment 1281?
Yeah, good question there, Blake. So again, CCPA is the core legislation that gives consumers control over their data, right? So that's, this includes the right to access or delete personal information. It allows consumers to opt out of having their personal information stored. CPRA, again, is it's a ballot initiative, and if it's passed in November, it's going to amend CCPA. And based on the slide that we previously discussed, it has implications on employees and consumers. So again, AB 1281 amends CCPA, and if CPRA does not pass in November, it puts the employee and B2B aspect of CCPA into effect on Jan 1, 2020. If CPRA does pass, and it is expected to pass, it pushes out CCPA employee and B2B provisions into Jan 1, 2023. So it gives folks a lot more time. And I'll flip back to this slide here just so everybody can sort of digest the difference between CCPA, CCPRA, and GDPR. So thank you for that, Blake. Any other questions?
Yeah, we got one more for you. So we want to talk about what might we expect in terms of data privacy at a national level?
Yeah, that's a good question. So currently there are 8 states that have legislation in effect or entertaining putting legislation in effect. So of those 8 states, California has built the most robust infrastructure, right? It calls for access, delete, opt out, opt in for minors, and so forth. But there's a wide variety of other states out there that are looking at this, long and hard. And if you set COVID-19 aside, I think a lot of that legislation would have moved forward rather rapidly. So I think you're going to look at, or you're going to see a lot of different states pushing data privacy in the coming months once we have COVID in our rear view mirror. And I think that, there's probably going to be some potential for some national legislation at some point to perhaps get the U.S. In alignment with what Europe's done from a GDPR perspective. But, that's one man's opinion in terms of where data privacy goes across the U.S. So, very good. Any other questions out there, Blake?
Was all. Thank you so much. I know I learned a lot.
Very good. Thank you.
Okay. Well, I think Joe, then we'll go ahead and wrap it here. As you said, I think there's plenty more to dive into. Hopefully, this gives you a good overview of the current legislation, the importance of data privacy, where it's heading, and we look forward to doing some more of those deep dives, as Joe mentioned, in the near future in some more RevGen sponsored webinars. So thank you, everyone.
Very good. Thanks, Carol. Thank you all.